and live.
All right, good evening, everyone. Thank you very much for joining us this evening. My name is Cameron Smith. I will be your host and moderator for our event tonight. Really great to see so many people showing up. It's a beautiful night, at least in my neck of the woods here in BC, and we still have lots of folks jumping on the call here tonight. We will endeavor to have a conversation about estate planning for an hour or less, and we'll present some material and leave some time at the end for questions. At MD, we have a mandate to reach out to our clients for education purposes as much as possible, and that can be done in one-on-one meetings, in our offices, or in a more traditional setting where we rent a venue and potentially have a meal and a conversation about a certain financial planning topic, and that is definitely not the reality that we are living right now. So we are trying some new things to still connect with all of you. That would include our one-on-one meetings being done over the phone or virtually via a platform called WebEx. And from a seminar perspective, we're trying this, and it seems to be going over fairly well because hundreds of you, literally hundreds of you across BC, are joining us here tonight, and that's great. As I said, my name is Cameron Smith. I have two colleagues that I will introduce shortly that will also be a part of this presentation. Before we get going, a few housekeeping items for us. You should see a screen on, or a tab on the right-hand side of your screen. For me, at least, it's on the right-hand side. This would give you access to a couple of things. One would be your audio connection. If it's spotty, you can try toggling back and forth from computer to telephone to none back to computer. If that doesn't work, there are dial-in instructions that you can use. You can stay connected via your computer for video and presentation material that we'll share, but the phone would be more clear if you are having computer issues. We are expecting as many as 500 people to join us tonight. We will try to, we're encouraging questions. We'll try to answer as many of them as we can. There is a questions tab. You can see a little triangle potentially on your screen. If you click that to point downwards, it will open a text box. It will be very difficult to answer all of your questions, but if we see themes during the presentation, we'll certainly try to address them at the end. And if there are questions that we don't get to, we will be able to run a report and answer those questions for you after the event. We could have someone reach out to you. We're going to try to keep things as interactive as we possibly can. So we'll launch a couple of polls throughout the session. You'll get a chance to vote. And we're trying something new with this webinar. As soon as it's done at about 8 o'clock, we'll close the webinar down and a web browser will automatically pop up with a short survey. And when I say short, I mean really short. It's 3 questions. The first one will be, was this worth your while to attend? The second will be, do you want someone to contact you? Do you have any questions after the fact? And the third will be, do you want us to touch on any other topics in the near future? As I mentioned, lots of folks dialing in tonight. Many of you are existing MD clients, but there is a pool of you who have never dealt with MD before. So I just want to take a moment to speak about MD, where we come from, how our evolution has taken place, and where we are now. So as you can see at the top left-hand side of your screen, MD was founded now 51 years ago. The CMA was lobbying on behalf of physicians from a financial perspective. Many folks across Canada at that time were part of employer pensions, and physicians were not. And the CMA said this isn't fair. So lots of discussion with the government. That resulted in something that's had an impact across the country, which is now known as an RSP account. Our investment, early days were very humble. We were a mail-in investment service where you would essentially pop something in the mail and get invested into the one investment solution that we have. But over the years, we have evolved significantly. We started hiring professionals, opening regional offices, to now where we are today. We have more than 1,500 employees, offices in every single province across Canada. I looked this morning, we managed slightly more than $50 billion in investments. And we also were very, very proud and very privileged to deal with more than 39,000 physicians. And of course, we also deal with their family members. We have over 100,000 clients across the country. When it comes to investing with MD, you can do almost anything. This is not a one-size-fits-all approach. We have some clients who come to us and say, I want to buy my own stocks and bonds, and maybe I want a margin account. No problem. We can absolutely do that for you. And as we move down the spectrum, some clients decide to delegate some of that day-to-day responsibility to us. There are some folks who say, I have no desire, no interest, and no expertise in managing investments, so I will let you help me. We have 4 different platforms and can really customize the approach depending on client need. So our focus today will obviously be estate and trust planning. It's a topic of conversation that many people are interested in at the moment. COVID, I think, has caused all of us to question our health, the health of our society, and to have your directions and your financial affairs in order brings a certain peace of mind. And fortunately, we're in really good shape here in BC, but it still caused people to think a bit more than they normally would. One of the things we always profess is that dealing with one component of financial planning in isolation is never as strong as looking at a financial plan as a larger picture. So estate and trust planning is very important, but it needs to also talk to an investment strategy, to a potential corporation or a holding company. Is there insurance assets? Is there debt that we need to know about? These are all things that we would want to take into account before simply focusing on estate planning. And this is something, of course, that we do here at MD. So I did mention that I would be joined by 2 professionals that I'm very proud to call colleagues. A little bit of history about myself. I joined MD in 1999 as a client. My grandfather was a physician in Edmonton, and he introduced me as a client to that Edmonton office. And my original financial advisor back in 1999 is still in that office today. I still get the chance to speak to her from time to time. I joined the firm as a client in 2006. I've held multiple roles, including senior financial consultant. I did a stint as the regional vice president in charge of our 10 MD management offices here in BC. And now I'm very proud to have joined the Signature team. MD Signature Private Wealth is the team that focuses on some of our more complicated estate planning clients and financial planning clients in general. I hold my certified financial planner and chartered investment manager designations. I am joined by Angus Stewart. Angus is an estate and trust advisor with the MD Private Trust Company based here in BC. Angus, I apologize in advance. I'm going to date you a little bit. He's been in the industry for more than 30 years in various capacities in both Ontario and British Columbia. He's a member of the Society of Trust and Estate Practitioners, and he holds also a certified financial planner designation. And I have to, last but certainly not least, I'm going to give a big shout out to Joanna. Joanna is with our Signature Wealth Management team. She is based in Toronto. So it is 10 o'clock, after 10 o'clock her time. We'll be done at 11 her time. Thank you, Joanna, for joining us. Joanna graduated with a first-class honors bachelor's degree from McGill University, a master's degree from Columbia University in New York City, and a law degree from the University of Western Ontario. She's an active member of the Law Society of Ontario and the Society of Trust and Estate Practitioners. And Joanna actually has a similar story to me. She came to know about MD through her family, as both her father and her brother are practicing physicians. So what will we cover tonight? We've done a bit of an introduction to MD. We want to look at some estate planning priorities, some general information that everyone should have in place. Which documents do you need to have in place? And there are documents in accordance to wills. There are also documents that should be in place during your lifetime as well. Some of you on this call may not actually have a will. I hope after this call you're motivated to get one, because we're going to tell you what happens if you pass away without a will. We will also tell you some of the tips to have a very good will and put something strong in place. Many of you may have been appointed as an executor in a will. That can seem like a really big honor. It can also come with a tremendous amount of responsibility. So we will review executor duties from the context if you are an executor in a will, or if you're thinking of who should be the executor of your will. We will touch on some of the documents that you would need in case of incapacity during your lifetime. And that is something our physician clients have probably come across in their profession. And again, some of these strategies will get a bit more complex. We want to try to cover some very general estate planning principles, and then maybe also cover some of the more complex options that may be available. And those may be options that people are reviewing now because of COVID-19, but they're also strategies that are strong and foundational moving forward. And at the end, it's perfectly natural with this estate subject matter. Very few of us deal with this on a regular basis. It is very, very common to have questions, and MD is here to help, and we'll review how we can do that. So we're going to get things started with a bit of a poll. Again, trying to keep this somewhat interactive. So we'll maybe launch our first poll. So 2 questions we'll have. What percentage of Canadians does our audience think have a will? We'll get that poll launched right now. I'm hoping that we're ahead of the curve here in BC, but we'll see what the audience thinks Canadians in general are up to. And so far, mixed bag, lots of votes coming in. Give another minute or 2 here. So about a quarter of the audience is saying 27% of Canadians have a will. 40% are saying a third of us as Canadians. 29% saying about half of us have a will. And we're a pessimistic crew, and only 5% of us as an audience tonight are saying that 62% of Canadians have an active will in place. So let's close that poll off. We'll shift over now. Hopefully we think highly of ourselves here in BC. What percentage, we'll shift the question over to what percentage of folks here in BC would have an active will? See some votes coming in now. So similar mix. I'll give another couple of seconds here. So again, about a quarter of us think that 25% of British Columbians have a will. 46% of us think 45% of people in BC have a will. About a quarter of us think 54%. And only 5% think that about 2/3 of us actually have a will in place. So we'll maybe close that poll off. And at this point in time, I'm going to turn things over to Joanna. And she is the estate expert, and she'll go through some of the results with us.
Thanks, Kim. Thanks, everyone. It's a pleasure to be here. Actually, according to a poll conducted by the Angus Reid Institute 3 years ago, 49% of Canadians and 54% of British Columbian residents have a will. So you in BC, you won. You won by a whopping 5%, so congratulations. However, I would say that I'd love to see both of those percentages higher. It also doesn't account for the fact that those who answer that they do have a will might not have a will that's up to date. So when I'm talking about a will that's up to date, it would mean either a will that's not in keeping with their current wishes for the distribution of their assets. It might not be in keeping with the types of assets that they currently hold, their personal circumstances in terms of whether they've been married, separated, divorced, a death in the family, a birth that they want to take into consideration in their wills. And of course, changes in the laws. So of course, all of those factors change over time, as you can imagine. So the Angus Reid Institute also did a poll that found that only 35% of Canadians say they have a will that's up to date. So what that means, you do the math, 65% of Canadians do not have a will that's up to date. So that's 65% of Canadians whose assets will maybe not be distributed to the beneficiaries of their choosing, or may not be distributed in a tax efficient manner, or maybe not in the most efficient way. So perhaps more assets will go to the government by way of fees or taxes than they would hope for, or the assets may be distributed with delays, that kind of thing. So we'd hate to see all that hard-earned money not go the way that people intend. So I want to be clear. So harping on wills right now, a will is a very important part of an individual's estate plan. It's not the entire estate plan. So there are many parts and considerations of an individual's estate plan to ensure that that's a good and solid estate plan. And we're going to be getting into those in a minute. So first, what I want to do is this term estate planning seems very general, and what I want to do is to specify exactly what it means. So estate planning is about, I think of it in 2 buckets. So it's about putting in place strategies to protect your wealth, your income stream, and your financial independence during your lifetime. It's also putting in place a framework for distributing your assets after your death. So those strategies, both to put in place during your lifetime and upon your death, are likely to change over time, no doubt. There's also the reality that your legacy extends beyond just managing your assets during your lifetime and distributing them past your death. It should also take into consideration the complexities of the relationships that exist during your lifetime and how your estate planning could affect those relationships after your death based upon the distribution of your assets. So I'll tell you a quick story. So I once had a client who had a son and a daughter. They didn't get along. She had made her daughter the trustee of her son's trust. The daughter didn't have a trust created when the mother passed away. She received her assets outright, so basically cash or assets in hand almost immediately. So as things stood, the daughter will essentially hold the purse strings to the brother's inheritance, which could likely make their already difficult relationship that much worse and could possibly lead to future litigation between the siblings. So it's certainly not a legacy that any parent would want, I would imagine. But I want to turn towards now, how do we think about what a good estate plan looks like? How do we evaluate that? So let's look to the next slide. Thank you, Cam. So each individual's legacy goals are certainly unique, and there are a number of important objectives that every estate plan should include. So the list of estate plan requirements will help you take stock of your own plan and make sure that you have the right one in place for you. So I'm going to take you through each one of them. So first, on the upper left-hand corner, so you need a plan that speaks to, as I mentioned, the management of your assets, but also your care during your lifetime if you cannot manage your assets or your care yourself due to incapacity or for another reason. Second, your plan should include a will that names executors who will be able to manage your assets in a timely, effective, and prudent way. Doing so would help to protect the size of your estate and would also help to minimize arguments and any future litigation among loved ones, interested parties, beneficiaries. Third, your estate plan should stipulate who will inherit your assets, the types and quantity of assets that will be distributed, when those assets will be distributed to your beneficiaries. Keep in mind, when I speak about beneficiaries, it could be individuals, it could be charities, it could be towards causes that are important to you. Fourth, your plan should stipulate how your estate should be administered. I also want to take a side note to say that if you are incorporated, the shares you hold in your corporation and the shares you inherit from your spouse or anyone else may form part of your estate. So it's important that you include those shares in your thinking. Fifth, your will should be structured to allow for tax-efficient distribution of your assets after your death. So what I mean by that is that your will should include strategies that could be available to your executor and powers given to your executor to allow for tax-efficient distribution of your assets and management of your assets. Sixth, in developing your plan, analysis of your finances by your advisors should consider the anticipated fees and taxes that would arise upon your death. So what does that actually mean practically? So we suggest going to your financial advisors, discussing the makeup of your estate and your wishes upon your death, certain assumptions, say when you expect or when, different factors at play, and ask them to estimate the payable fees and taxes that would arise upon your death. Why that's important is because once you receive that number, you would be able also to estimate the amount of liquid assets that you would have to cover those fees and taxes. And if you don't have enough liquid assets to cover those fees and taxes, there are strategies that you could put in place now in order to mitigate that, so that in the future, your final estate could cover those fees and taxes and leave even more assets to your heirs. So lastly, your estate plan would fulfill your moral and legal obligations, ensuring the well-being of those who are dependent upon you, and also helping to maintain family harmony. So the last thing anyone would want really is litigation between family members because former spouses, dependents, creditors, or others who didn't receive what they were entitled to receive from their estate engage in litigation. So I put together this slide, just a very practical slide. So which documents should I have in place? On the left-hand side, I put documents that I believe everyone should have in place, organized and accessible. On the right-hand side are documents that you may need to have in place depending on the advice from your legal and tax advisors and others. So on the left-hand side, I'll just go through them quickly. Your wills, we talked about that. Enduring powers of attorney and representation agreements. I'll be speaking to that in a bit. Income tax documents, an inventory and location of assets. So when I'm talking about that, it's basically, which assets do you own and where are they? So where are your bank accounts? Which institution? Where are your pieces of real estate? And of course, a list of professional advisors and their contact info. So if they apply to you, you would need to organize and have centralized and accessible your incorporation documents, life insurance policy statements, and trust documents, which includes deeds of trust, any amendments to those deeds, any documentation relating to those trusts, and domestic contracts. So if we were American, I would be saying your prenuptial agreements. It's a very common term, but we're Canadian. So I'm saying domestic contracts, and that includes marriage contracts, cohabitation agreements, separation agreements, divorce contracts, parental contracts, orders relating to those relationships by the court. So I know everyone on the call thinks that having a will is important, but I want to look at what it would mean if you didn't have a will. So first, if you didn't have a will, the choice of an executor would be out of your control. Your estate would be led through a very lengthy and expensive process of having someone appointed by the court. That expense would be paid by your estate, ultimately leaving fewer assets for your beneficiaries. Your assets would be distributed according to a provincially legislated formula, which is likely not what you would choose. Your children would receive their inheritance at age 19. And there would be no consideration if any of your beneficiaries had any special needs or need greater control of their spending, or you'd prefer them to not receive their money simply outright in a big pot, essentially. There certainly would be no tax planning. So the likelihood of the government receiving more by way of fees and taxes is certainly greater than otherwise. I'm going to sidestep and tell you a little bit of a story. So a number of years ago, I had a client whose husband recently died. The client was a BC resident. She built an estate with her husband, essentially worth $2 million rather. The vast majority of that $2 million was in the deceased husband's name only. They had one disabled child and another child who spent money almost as quickly as he earned it. Both kids were in their 20s. The husband died without a will. So in the end, after taxes and fees, my client received $750,000. The other $750,000 was divided equally between the two children. And with these distributions, the client had to move out of her family home. She had to extend her retirement date by 15 years. The disabled child's government benefits ceased because he had all these significant assets. The other child spent his inheritance within 2 years. And so I'm sure everyone could agree, could assume that the situation was far from ideal, which was certainly the case according to the client. She certainly didn't want to make the same mistake and thoughtfully engaged in the process of designing her will. So simply put, a will covers all of the assets that you hold personally, as well as the shares of any private corporations. Though it doesn't necessarily include all those assets that an individual holds jointly with right of survivorship with one or more other individuals. So we often see homes, chalets, cottages, some non-registered investment accounts held jointly between spouses, sometimes jointly between an individual and their parent, their child. But what we typically see in a will are the following. So we see personal effects. What we mean by personal effects is basically household items, including collections, art collections, coin collections, other types of collections, jewelry, those kinds of things. You can also include in your will specific instructions. So, for example, if you want to gift $25,000 to your Aunt Sue, but should she die before you, you don't want her children to inherit that $25,000. You can include that in your will. It would be a lot more tactful than what I just mentioned, but you could include that instruction in your will. You can include charitable gifts, which could be a very meaningful component of your legacy. Your will addresses how the remaining assets are divided among your beneficiaries as well. So your beneficiaries could receive their assets outright, so as immediate as they could, whether that's cash in hand or other assets, or they could receive assets according to certain conditions outlined in a trust. So the conditions outlined in the trust could take into consideration the beneficiary's age, their future educational expenses, any emergency medical needs, perhaps they're disabled. We can take into account that factor so that it doesn't infringe on their eligibility for government benefits. Could take into account perhaps that they spend money irresponsibly, and so maybe there's a more staggered approach to the distributions, or someone who either has creditors or perhaps due to their profession is likely to have creditors either now or in the future. So what I'm going to do now is I'm going to turn the floor, I'm going to pass the floor over to my colleague Angus, who's going to dive a bit deeper into the rules relating to BC. He's our local estate planning specialist.
Thank you, Joanna, and welcome everyone. My name is Angus Stewart, and I'm an estate and trust advisor with MD Private Trust Company, and I've been with the company almost 20 years. And testamentary freedom varies from province to province in Canada. In British Columbia, we have what's called the Wills, Estates and Succession Act. And within the act, there's legislation which states that should a spouse of a deceased person or a child of a deceased person not be satisfied with their inheritance, they can apply to the court to vary the terms of the deceased will. I'm not saying anyone would do that, or if they did do it, whether or not they would be successful. But what I'm doing is making you aware of the act. We do see these court applications in some estate administrations, and it could be, due to a disgruntled child, an estranged child, second marriages, mixed families where one side of the family feel they're not getting what they should be. Promises made to children about purchasing a property like a farm. So be aware of it. The outcomes of any court application can never be predicted with 100% certainty. And in fact, the ones that we see are often settled out of court simply because it costs so much time and money to go to court, which is paid by the estate. Now, keep in mind the wills variation legislation that we have in British Columbia just covers estate assets. It doesn't cover assets bypassing an estate, such as life insurance payable to a certain person, joint assets that will flow outside a person's estate, or perhaps a living trust where assets are placed into a living trust during a person's lifetime. On their death, they don't form part of their estate. Estate administration can be complicated and time-consuming and stressful. I find in many estates we look after, many of physicians' estate, there is real estate, there is corporations, there can be blended families, there can be children from a second marriage, non-resident assets such as a condominium in Hawaii. So the executor has to be knowledgeable in a lot of fields. They ideally would be a neutral third party, not have any conflicts. They would have some business acumen, knowledgeable about taxes. They should be a good project manager, and ideally your executor should be a Canadian resident. And the reason is if you have a son or daughter, let's say they're working in San Francisco as an engineer, a software engineer, and suddenly their put into the role of being an executor of your estate, your estate can be treated as a non-resident estate for income tax purposes, even though you may not have stepped foot in the United States for years or decades. And also the children in San Francisco, or the child in San Francisco, they have to do another level of reporting to third parties like the IRS, because they control assets in the office of an executor and trustee. So I think there's also considerations of being geographically a distance away. So consider the role of the executor very carefully. This is a busy slide, main responsibilities of an executor. I'm not going to go through all the hundreds of duties of an executor in great detail, but I would say, just from a high level, typically what we'll see with a couple is a couple will appoint each other as their executor, and on the death of the last one of them, or on the death of a single person, they appoint someone else, and that person could be a child, a friend down the street, a trust company, whoever you think is appropriate. Typically, when there's a surviving spouse, many assets are in joint names. The surviving spouse has to do certain things like file a final tax return for the predeceased spouse, apply for pension benefits, death benefits, life insurance benefits, and change joint assets to their own name, which could be reorganized in a shareholder registry for a corporation. We help out a lot with this, but sometimes after a meeting with a widow or widower, they're fine to go do these things themselves over the course of a year or two. On the death of the last person, as I said, or an individual, things are a lot more complicated, and that's because assets cannot roll over to, say, children and other beneficiaries the same way they can between spouses. So what you have is an executor who has to take the original will and go to the Supreme Court of British Columbia and submit it to the court with a number of other documents and affidavits, and get the court to stamp it as the last will of the deceased. So what that is called is probate. And the reason it's necessary is because third parties such as banks, MD Management, the Land Titles Office, ICBC, they're afraid to take the executor's instructions on what to do, because they're afraid if they give all these assets to the executor to distribute to beneficiaries, another more later dated will might pop up with a different scheme of distribution. So probate releases these third parties from liability. So the court keeps the original will, they issue a court certified copy, and then the executor takes notarial copies of that to deal with third parties. And what we try to do as a trust company, we try to have that application into the probate court within about 8 weeks of someone passing away, which can be a pretty tight time frame. I've talked to the odd physician where they say, oh, my dad's passed away and I'm the executor. And I say, oh yeah, how are things going? And they might be 2 years into it and not have obtained probate yet. So even at the fastest amount of time, if a probate application goes into court within 2 months, it's taken the court now 3, 4, 5 months to issue probate. So during that time, the executor still has to protect assets. They're still responsible for them. And and then some people ask me, why does an estate administration take so long? It's because by the time you're done dealing with probate, waiting periods for wills variation applications, dealing with beneficiaries, filing corporate personal tax returns and estate tax return, final income tax return. By the time you get a clearance certificate from the Canadian Revenue Agency, it could be 2 or 3 years into it before you know it. And that's even if you get going from the get-go. I should talk about fees. Some people ask me about fees, and generally in Canada, the most an executor can charge to be an executor is they can ask for 5% of whatever the estate value is. And that could be a trust company, that could be a child, that could be a neighbor. It doesn't matter who the executor is. I know on the Public Trustees website, if you look that up, generally they charge between 5 and 7% to administer an estate. And that's usually for someone who dies intestate without a will, as Joanne alluded to. The court says an executor earns that fee for 3 reasons. One is the time they spend on the estate administration. So you can imagine someone starts an estate administration and they have no intention of taking a fee, but then 3 years later they rethink that. And also they have to be successful. They have to do a good job in the estate administration. And the third thing is the liability they take on. The court recognizes there's a certain amount of liability that an executor has to take on. As far as a trust company being an executor, people ask me a lot, oh, does everybody need a trust company as an executor? And I would say no. Probably 90% of the people out there don't need a corporate executor, but I found in many of the physicians and their families' estates that we do look after, the nature of those estates are such that, as I said, with family issues, corporations, non-resident property, condo in Whistler, there's enough capital there where the trust company can add value. So if let's say our fee ends up being 3% or something like that of whatever the estate assets are, hopefully we add more than that in the value of tax elections we apply for and so on. Joanna is going to talk about enduring powers of attorney.
Thank you, Angus. So I mentioned earlier, enduring powers of attorney is one of those documents that everyone should have. So what is it? So it's a document where you name one or more individuals or a trust company to manage your assets on your behalf if you're unable to, whether that's due to incapacity or for another reason. So if someone doesn't have an enduring power of attorney, when they lose capacity to make decisions with respect to their assets, what happens is that a government office or officer can be given the authority to manage your financial affairs for you. So basically the government is managing your finances, your other such property, your real estate or whatnot, or the court can appoint one or more people to do so on your behalf. So as you can imagine, neither outcome is ideal, and both can result in significant and unnecessary complexity, delays, and expense for you and your family. So most people would like to decide for themselves which trusted individuals or perhaps a trust company should play this role should they become incapable of doing so for themselves. So in terms of who should be appointed in this role, it should first and foremost be someone who you trust. It should also be someone who brings a level of experience and skills relevant to your personal and financial circumstances. It's also important to appoint someone who perhaps is familiar with your family members and those who live near you. It would also be handy if that person, at least one of those people appointed, does live near you. So just to be clear, Cam, don't smile. So to be clear, the person who you appoint as your attorney does not need to be a lawyer. Lawyers are fabulous. I'm a lawyer, they're great, but just because it's called your attorney does not mean that it needs to be a lawyer. It can be an individual or a trust company. So you can appoint more than one person to act as your attorney, and that can be beneficial for many reasons. So for instance, it can be hard to find someone who meets all those criteria of trustworthy, lives near you, has all the skills and experience, and is familiar with those around you. Naming more than one person also helps to ensure continuity in case one of the people appointed can no longer act for whatever reason. It also creates a level of accountability for each attorney acting, and thereby reducing the potential for financial abuse. So we've talked about wills, we've talked about enduring powers of attorney. Now let's turn our attention towards representation agreements. So you're probably thinking, she's talking to me about representation agreements. Like I realize that this is an audience that is lightly familiar with representation agreements. However, as a quick refresher, just to put everyone on the same playing field, a representation agreement is a document where an individual appoints one or more individuals who would make decisions on your behalf with respect to your care. So when I say care, that certainly involves medical decisions, but it also involves other personal care decisions, such as what you eat, what you wear, where you live. Basically anything that's not decisions with respect to your assets that your attorney named in your enduring power of attorney would make. It can also address end-of-life issues. The person or people who you name would only make decisions that you are unable to make for yourself. So if you can make decisions with respect to certain care, then you could make those, and you should, if you choose. So a consequence of not having a representation agreement is that, as you likely know, is that an attending physician can institute a process whereby he or she will appoint a, quote, temporary substitute decision maker to make those decisions relating to your healthcare. So as you likely know, the procedure is cumbersome. It also takes time to put in place and can cause frustrations for those who would otherwise be appointed and who you trust, perhaps your children, so on and so forth. So in a representation agreement, similar to an enduring power of attorney, you can appoint more than one person to act at any given time. But I do want to caution you to think about who you name at any given time. So those individuals should be able to work well together. They should also be able to work well with those appointed as attorneys in your enduring power of attorney, because as you can imagine, the decisions that you make with respect to, or that are made with respect to your financials and other property could go hand in hand with the decisions that are made with respect to your personal care. So the example I typically use is a decision to decide between several different long-term care facilities. So the decisions that go in, the considerations that go into that decision have a financial aspect. Could you afford certain facilities? And also the other aspects of which one would you prefer, which one is appropriate given the care that you need or that you're looking for. So while those appointed in your representation agreement, they're called representatives, don't have to reside in the same city or province or jurisdiction than you, it might be helpful if at least one of them does live near you in order to be able to personally consult with your physicians, instruct and supervise caregivers, check on you, and hold care providers accountable. So I'm going to turn it back to Angus to address certain strategies that could be implemented either during this time of the pandemic or otherwise.
Thanks, Joanna. Yeah, things to consider during the pandemic. We're of course talking about your estate plans, but I would also, pause here to say, think about older family members at this time. It's a good opportunity to ask them questions. Do they have a will and power of attorney in place? Do they have a representation agreement for healthcare? If so, where are they? Do they keep them in their house, at a lawyer's office, at a trust company, in a safety deposit box? If they're in a safety deposit box, who has access to the safety deposit box if those documents are needed? And ask them questions about their assets. How is their house registered? Are they deferring property taxes? Those are all important questions that it's easy to ask older family members now as opposed to later when there's an emergency that comes up. As far as strategies for your estate plan, I'm going to talk about a few things at a fairly high level. These are fairly complex topics. You can look at establishing a living trust during your lifetime, and the benefits are numerous. Assets transferred to a living trust now, such as a principal residence, non-registered investments. On the death of an individual, they can bypass the provincial probate process. For a single person over the age of 65, it's called an alter ego trust. For a couple where at least one is over the age of 65, it's called a joint partner trust. And so assets are transferred in there. A couple or single person will use them however they want. They're their assets. It's just that the registration of them are no longer in their name. They're in the name of the trust. So if they pass away, they don't form part of their estate. If they lose capacity one day, it's much harder for a third party to take advantage of them when money is in a trust. Number two, creating a family trust using a prescribed rate loan. If there's a family out there where they have non-registered capital, or perhaps they just received an inheritance, they can theoretically take that capital, they can lend it to a family trust, and the family trust pays them interest on that money. So the amount of the interest is called the Canadian Revenue Agency prescribed rate loan, and it's currently 1%. So that means if you loan $1 million to a family trust, the family trust has to pay you $10,000 a year of interest, which you report on your income tax return. However, the income and growth generated within the family trust can be allocated out to family members in a lower marginal tax rate. And this is worth exploring. Again, if there's enough capital, not in a corporation, not in an RSP, not in real estate, but non-registered. You can take advantage of number 3, using a permanent life insurance policy. I've had a few physicians come to me and say, Angus, if I could go back in time and give my younger self advice, it would be to purchase more insurance. And they're not necessarily talking about term life insurance. They're talking about permanent life insurance, which stays with you your whole life. And the government lets you over contribute to the plan and create an investment or component which grows as well. The benefit of this, if you have a permanent life insurance policy in your own name, if you pass away, you can name beneficiaries. So that means in a second marriage, you can name children from a first marriage as beneficiaries. So it does have its uses. It does create options, and it's also, can be a good investment. Number 4, freeze in the fair market value of your private corporate shares. This is known as an estate freeze. You may have read this in newspapers or saw it in a seminar, and it can get complicated, but I'll explain it to you very simply. What it means is if you have private corporate shares, you can create a new class of shares, a new class of common shares, which you can make your children the owner of, and it would be very effective if, for example, children were in their 20s or 30s. So let's say the corporation owned a couple of apartment buildings and it gave off a lot of income. And in the future, the parents who created the estate freeze, they retain the controlling shares of the corporation. All the gains up to the point where they did the estate freeze accrues to the parents, but the future growth accrues to the children. So in the future, parents pass away. Yes, they might have to pay some capital gains on the private corporate shares up until the time they passed away, but the children can go on retaining their shares and keep the corporation intact if they wish, and continue to collect the income from the corporation, and it could still hold apartment buildings and so on. So it can be very, very effective in that respect.
Well, thank you, Angus and Joanna. I think a good combination so far of some general estate planning practices as well as some strategies that are a bit more specific. Again, I can't reiterate enough, an estate plan built in isolation is not going to be that effective. A proper plan will be part of a larger financial plan, and that comes with getting to understand your family, who's important to you, the people in your life, the priorities in your life, the goals for your life. What are your current investments? Is there a corporation? Are there non-registered assets? Do we have some debt? Is there insurance? All of these are factors that definitely need to be brought into consideration. And this may seem to some of you like a bit of an insurmountable task. All the documents you should have in place, all the things that would need to happen. There are people to help you, and there are professionals that can break this down into bite-sized pieces so you don't have to think about it all at once. So MD is definitely here to help. Now, we are getting lots of questions. I promised that we would wrap this up by 8 o'clock, so we've got about 10 minutes to get to them. And maybe out of fairness to give both Joanna and Angus some time to have a bit more limelight before we shut things down here tonight, I'll go back and forth, and I'll ask a question of each of you. So Angus, maybe I'll start with you. So maybe this is like speed dating, quick answers here. We'll get through as many as we can. We're in a COVID world where a lot of professional offices are not open. If someone wants to update an estate plan, create a will, how do we do that without being able to sit across the desk from a lawyer and sign something?
That's a good question, Cam. And yes, documents can still be signed. you know, governments, law societies, businesses, lawyers, they're all looking at rethinking the way they sign documents to accomplish tasks at a distance. So I've heard of lawyers signing on park benches in a client's garage. One of the lawyers in Burnaby explained to me at the beginning of the COVID crisis, he was signing documents through his office window. So that made me laugh a bit. It made me think of the drive-through divorces in Las Vegas. And so, yes, it can still be done. So don't wait until the end of the crisis before considering your options.
I know too, on the financial investment side of our business, we've evolved very quickly when it comes to electronic signatures through something called DocuSign, and I think in the legal world that's progressing as we speak. So there probably will be some options there as well. Joanna, maybe moving over to you. It was mentioned in the presentation that a good idea maybe for people that are older in your life, could be an elderly parent, to have some of those conversations about their assets. Maybe if their plans are in place, is there a spot where their documents might be gathered? In your experience, Joanna, how would you ask that question in a non-awkward, non-confrontational, non-invasive way?
So that's a great question. I actually got off the phone with a friend earlier and helped her work through that question with her mother and stepfather. So, and it's one that I've encountered too. So Cam told the audience that earlier that I was inspired to join MD in part because my brother and my father are practicing physicians. What he didn't reveal was that they, as well as others in my family, are psychiatrists or other therapists. So with every question comes, why are you asking that, right? Let's dig deeper. It's a process. So, but nevertheless, I haven't shied away from addressing it. It's important. It's obviously sensitive. And the way that I've approached it myself and I've counseled others to approach it is to say, I need to know certain things. I need to know if I'm appointed in a fiduciary capacity. Have I been appointed, or who has been appointed as an executor, as an attorney in your enduring powers of attorney, as a representative in your representation agreements, as trustees of any trusts? I need to know these things in order to protect you and your estate, either during your lifetime or upon your passing, for the benefit of those who will inherit from your estate. What's not important, what often gets people's backs up, is the question of how big is your estate? That's not as necessary to know as much as the roles that I just outlined and perhaps the structure of one's estate. So does someone own shares in a private corporation, maybe a medical corporation? Does someone own shares in another type of holding company? Are there opcos that you may not know of? Above and beyond that, so where are your estate planning documents? Do you have them? If so, how are they accessed? If they're in a safety deposit box, that could be a problem because those appointed as executors would need to be able to prove that they're executors in order to access your safety deposit box. So if you rest on who's appointed in a fiduciary capacity and where are your original documents, as well as the laundry list of documents that I outlined earlier in terms of your list of advisors and inventory of assets, then it becomes a much more comfortable conversation. Once you get through that, I would only imagine that conversations would evolve more organically. You might have questions. If they feel comfortable asking them, absolutely. But you really do need to, of course, above and beyond, be respectful and only ask them questions that they would be comfortable answering. And if they don't, that's fine too.
Excellent, thank you. Angus, maybe going back to you, is a handwritten will legal in BC?
Hi, Cam. Yeah, that's a good question. And now it is. It didn't used to be, but under our new WESA legislation, Wills, Estates and Succession Act, which came into effect about 4 years ago, the court will look at other testamentary document, such as a text message or a handwritten holograph will. That's not to say it won't cause some delays. It could be a judge has to review it. You're better off to go get one properly typed and signed and witnessed. But yes, it can be used.
I think, long story short, and it's been interesting as the three of us were getting prepared for this presentation, lots of dialogue around wills and some of the subject matter we should cover. And a handwritten will could certainly potentially pass along some simple instructions, but it may not be, as we had talked about earlier in this discussion, nearly as complex and sophisticated as one would want it to be. And Joanna, you used a quote that's really resonated with me. One of the best parts of estate planning is we want to ensure that CRA is not the largest beneficiary of your estate. So some of that tax advantageous planning is obviously very, very strong. Couple more questions here. I'm just cognizant of time. There was a question that came in. Is there a legal way for people who buy an investment property in joint tenancy to draft a legal document that allows them to pass that property to their child or to their children? I don't know who might want to handle that one.
I can take that. So absolutely, that's a contract. That's a so what you would need to do is you'd have to retain a lawyer and provide all the details that you are wishing the document reflect. And it should be an open conversation with the joint owner or owners. But absolutely, that's a very typical and very thoughtful process. And I would encourage all joint owners of real estate to have such an agreement in place.
Good. We'll maybe end it there. There was a couple more questions that are a bit more technical in nature. We certainly have them recorded and someone can reach out to the people who asked them. One of the questions was about dual wills in BC. There were some further questions around clarification of fees. I think the dual will discussion will probably take more than the 2 minutes that we have left, but we can certainly follow up and answer that question. I think moving forward, I want to mention, if people have questions, they can email me directly. There's all kinds of resources on our website, and our website is not a difficult URL to remember. It's simply md.ca. I'd encourage you to go and download some of those resources. I will also give you a reminder from the beginning of this conversation today, as this webinar closes, there will be a web browser that pops up and gives you a chance to articulate, was this a good use of your time? It will also let you indicate if you do have a question. And in this subject matter, there are no bad questions. It is not something you deal with on a day-to-day basis. You can indicate that you may want us to reach out. And the third question would be, do you want further subject matter in the future? At this point in time, I want to say a huge thank you to Joanna and to Angus, and a huge thanks to our clients. It is an absolute privilege to deal with all of you. Thank you for joining us, and please stay safe. Good night, everyone.